takes forever to grant, to decide on a patent application. It's the main problem used to be in the pharmaceutical cases. Nowadays is basically widespread. In basically any technical area, a patent applications may take more than 10 years to be decided by the Brazilian PTO. But there is a compensation. Our last bullet in these slides, there is this Article 40 of the Brazilian IP law that says that the patents in Brazil will have 10 years from filing or 10 years from grant, whichever expires later. That leads to the fact that the majority, I wouldn't say the vast majority, but the majority of patents being granted right now in Brazil, they have a term of 10 years from grants. Depending on the technical area, if it is a regulated sector wherein before launching your product, you have to perform a number of tests, a number of clinical tests, a number of environmental tests in the case of agrochemicals, it may not be a bad situation. I mean, having in Brazil, maybe an important market, a patent that has a term of 10 years from grant. In a number of cases, a number of important products, the loss of exclusivity worldwide is year X, and in Brazil is year X plus 3, sometimes plus 4. What I'm trying to say is, depending on the area, I mean, some of my clients, I have to admit, they are quite happy with this situation in Brazil. Some of them even ask me to delay even more the patent prosecution, but I say that's not possible. It's delayed already too much. And there is the possibility of fast-tracking, of expediting the patent the examination in Brazil if there is a potential infringer, not a real infringer, but a potential infringer. In this case, you have just to send a warning letter. Warning letters are very common in Brazil, no problems about that. So a half-page warning letter, and with this you file a request to the Brazilian PTO to expedite the examination of the patent application. So instead of 10 years, you may have your decision on the patent application within, say, 1 year. Okay? A situation that, to my knowledge, is unique to Brazil. For pharmaceutical patent applications, okay, we have Anvisa in the scenario. Anvisa is the Brazilian regulatory agency. Okay, they grant the market approvals for agrochemicals, for medical devices, and for pharmaceuticals. And since December 1999, they also have a say on the examination of pharmaceutical patent applications. This came out of the current law dates from 1996, and this change in the law came out of the blue, and we were very surprised by this introduction of Anvisa, basically as a patent examining body. So the situation, making a very long story short, the situation right now in Brazil is that in a number of cases, I would say the majority of the pharmaceutical patent applications, Anvisa will perform the substantive examination before the Brazilian PTO. The case will be filed before the Brazilian PTO, but Brazilian PTO, when the examination starts, it will send to Anvisa. Anvisa, in most of the cases, will perform a substantive examination, prior art search, and a check novelty, inventive step. And if the case is allowable, the case will be sent back to the Brazilian PTO for another substantive examination. So apparently there was this idea by the government to have maybe some sort of a power on the granting of pharmaceutical patent applications. I don't really see a real rationale on all this, but the fact is that for pharmaceutical patent applications, we have not only one, but two examining bodies. The good news is that in my last statistics says that in 84% of the cases, Anvisa grants their approval to pharmaceutical patent applications, and only 16% they deny it. And even if they deny, it is possible, and the case in many situations, to file a lawsuit against Anvisa, but at the federal courts in Brasilia or in Rio de Janeiro. Those are the most common venues. And there are not, again, no problem against that. It's very common to sue governmental agencies in Brazil. And in terms of case law, the majority of the cases, almost all of the cases, are being decided against Anvisa. So the Brazilian courts are understanding that Anvisa would have only a say, an opinion to be given in case of public health issues, not substantive examination of patent applications. Okay? In terms of patent litigation, in Brazil we have this dual or bifurcated system. For infringement of IP rights, you have to file the lawsuit before the any state court. There are 27 states in Brazil, and you have to select the venue. I'll talk about this later. But the infringement will run before a state court. In terms of IP validity and discussion of possible revocation of a patent or a trademark registration, this discussion is before a federal court. Why is that? Because the Brazilian PTO must be a co-defendant. So if you have a governmental agency as a defendant in any lawsuit, you have to go to a federal court. Venue. This is important in Brazil. Brazil is a big country, so you have to select, you have to be careful about selecting where you are litigating because things may get complicated even in terms of logistics. So in general, the general rule, the general civil procedure rule is that I have to file at the seat of the defendant. But if the infringement is already taking place, you can file the lawsuit anywhere where the infringement is really occurring. So in case of a sale, for example, of a drug, pharmaceutical drug, in general, it is when it starts to be sold, it's sold anywhere in Brazil, so you can file anywhere. But in general, a number of those lawsuits are filed before the São Paulo. São Paulo is the biggest city in Brazil, at the São Paulo State Court, and quite close to my office, so it's very convenient for me. And there is no special grudge of those judges against patents or against foreign patents, nothing like that. So it's a good day to have your fair day in courts. There are no IP specialized courts in Brazil, except in Rio de Janeiro, federal and states. And in São Paulo, but only at appeal level. And sometimes my clients say, how you explain a complex patent case to a judge that has no technical background? Well, that's my job, to try to make things understandable even to a lay person. And in any case, the judge will designate, he or her will designate a technical expert of their trust, of their confidence, to act as an advisor. One important consideration, IP infringement in Brazil is both a crime and a tort. No one goes to jail, maybe some community service, painting a wall or cleaning one street. But in patents, it's really rare to see a criminal infringement lawsuit. But it may come very handy to get your evidences. There is a specific provision of the penal procedural code, the criminal procedural code in Brazil, that provides for a criminal search and seizure. And this criminal search and seizure is just to collect evidences of a possible crime, in this case, patent infringement. So, for example, the infringing product is not yet in the market, but you know that they are in the warehouses of your competitors. You may request a criminal search and seizure in spite of the scary name. Actually, it is only to collect a few samples of the products, and examination, technical examination, again, by a technical expert designated by the judge, will be performed, and there will be an opinion whether there is an infringement or not of the patent. With this opinion, you can file a civil lawsuit seeking a preliminary injunction. Very few times in my professional life I saw an infringement lawsuit in Brazil that has no preliminary injunction request. Almost all of them will have it, and in statistical terms, the Brazilian judges are somewhat willing to grant those preliminary injunctions, forbidding the sale of the infringing products right away before further studies in the civil lawsuits per se. I drafted one day this graphic. I like graphics. So basically, you have three instances in Brazil: trial level, appeal level, superior. Okay. It may start with a discussion about venue, not really common. It goes to the trial level, okay? And there will be a decision on the preliminary injunction. That's a specific situation of Brazil. We love appeals. Everybody has the right to appeal. And we also like interlocutory appeals. It's provided for in the procedural codes. So depending on the decision on the preliminary injunction, there will be an interlocutory appeal, so it goes to the second level, to appeal level, by the losing party, someone that whether the preliminary injunction has been denied or has been granted. After there is a decision on a preliminary injunction, the case goes back to the trial level, and then there will be a designation of the technical expert. Sometimes there is a discussion about the specific technical expert that has to act in a given case. Sometimes there is discussion about the qualifications, about the technical expert. I've seen pharmaceutical cases where civil engineers were designated as technical experts. So again, there may be on the decision by the trial judge another interlocutory appeal so that the appeal justices can decide on the name of the technical expert. Back to trial level, technical phase done, maybe, depending on the technical expert decision, another request for a preliminary injunction, and finally the sentence when the case goes to appeal. Any decision on the appeal level is appealable to the superior court. I'm just finished. Some company says that, oh, Gustavo, you must be very busy in the pharmaceutical area with infringement cases. Apparently, there are a number of patent infringement cases in Brazil in the pharmaceutical area. There are not. I mean, we have pharmaceutical patents since 1996. Before that, we had no patents, no pharmaceutical patents for products and processes. Okay? And since then, 1996, we have only 38 lawsuits, all of them in São Paulo, all of them handled by our firm. And of those 38, 30 are very specific type of lawsuits. They are against distributors to galenic or compound pharmacists. It's a very specific situation, maybe unique to Brazil, and related in general to lifestyle drugs. So I wouldn't even count these as real patent infringement lawsuits. The real patent infringements are only 8 against local laboratories, I mean Brazilian pharmaceutical companies, all of them relating to formulation patents. Almost all of them, the discussion is infringement by equivalence because the defendant changed the formulation of the drug, and all of them still under the technical examination phase. So my take from this is that at least pharmaceutical patents in Brazil tend to be respected. It's very difficult to see a situation where a drug is launched at risk. I mean, when there is a patent, sometimes even a patent pending, and even though someone launches the drug and faces the possibility of receiving a preliminary injunction against them or even paying damages in the future. I'll have my last slide on this. So recent cases relating patents in Brazil, second medical inventions. There used to be a discussion whether these sort of inventions were really patentable in Brazil. Of course, the industry of the copy always try to present these arguments that second medical use inventions lack novelty, but the fact is in 2014, the Federal Appeal Court in Rio de Janeiro handed down a case confirming the possibility, the notional possibility of patents for second medical uses. Again, the lawsuits against Anvisa in general are very successful in terms that basically barring Anvisa to perform substantive patent examination to pharmaceutical patents. There is no data exclusivity for pharmaceuticals in Brazil. Around 10 lawsuits were filed. We tried it on the basis of Article 39.3 of TRIPS agreements, on the concept of unjust enrichment, on the concept of unfair competition, but so far they have not been successful. So data exclusivity for pharmaceutical products is not really there. Only for agrochemicals and for veterinarian products. There is a specific law for that. No linkage in pharmaceuticals in Brazil. Again, 3 lawsuits were attempted, but so far without success. And no decision on compulsory license. Why is that? Because there are no compulsory licenses in Brazil, only one for the 5-year drug 10 years ago. And it was a compulsory license requested and granted to the Brazilian government. So instead of buying from the patentee, they can buy from anyone. And apparently, it has been a bad experience. The idea was to manufacture locally the products, and this has not been possible. That's what I'm told. And it seems that the Brazilian government will really be reluctant in addressing this issue and handing down and compulsory licensing another patent in the next few years. So those are, I will skip my parts of about PDPs on the benefit of time. And thank you very much for your attention. And I will be happy to answer any questions you may have. Thank you.
Okay, that was the first non-Indian presentation, and we are coming now to an Australian presentation by Richard Baddeley or Baddeley.